Welcome to Shenkman Education. My name is Marty Shenkman. The topic of this video clip is compensation of trustees and executors, generally fiduciaries. These are all people in various positions of trust in a lot of your estate planning documents. So you may name an agent under a durable power of attorney, a trustee or successor trustee or co-trustees under a revocable trust. You may name an executor under your will. All these people are fiduciaries and they're all entitled to compensation. First thing you have to do, get the governing legal document. For an estate, it's the will. You check, are there codicils that have been signed amending the will? For the revocable trust, it could be a revocable trust, it could be an amendment to the revocable trust, it could be an amended and restated revocable trust. The difference between an amendment is it may be a short couple-page document that just changes a specific provision. Amended and restated, it's like a whole new trust that supersedes and obviates the prior trust. For a will, for a trust, make sure you have all the documents. For power of attorney, some people sign multiple powers of attorney. It could include a standard bank form, it could include a standard state law, statutory form, it could include a more comprehensive form somebody prepared online or hopefully had an attorney prepare. Hopefully, because it's a lot more complicated than most people realize. All these people are fiduciaries. So the first question in compensation, you have to look at the document. Does the document say what type of compensation they get? Does the document say no compensation? Many standard forms, even lawyer-prepared forms, will just routinely say no compensation or no compensation to family trustees. How do they define family? So the first step in the process is to understand what the document says. The second step is to look at state law, and it's going to be state law that applies to governing that document. So if somebody's in a particular state and they're incapacitated and they signed a power of attorney or a revocable trust under that state law, it's that state law that applies. But also be careful. It's possible, and it's sometimes intentional, that people will name a different state law. So if you're doing a revocable trust, or even more so an irrevocable trust, you may name, even though you live in state A, you may name state B law because the laws in state B are more helpful to what you're trying to do. Now, conceptually, if you name a state law applying in an irrevocable trust, that state law that you name should govern. But there could be issues with that are beyond what we can do today, where your home state, where you created the document in the trust, may have some interest in having its law apply to certain aspects of the trust. But the bottom line is you got to first understand what's in the document as to compensation, and secondly, understand state law. And if there's distinctions between them, differences, you have to make sure you understand which overrides or governs as between state law and the document. Many legal documents, wills and trusts, for example, will simply default to state law and say trustees entitled to the commissions permitted under state law. But you can't assume that. There's often exclusions where people are not permitted to get compensation, and some documents will go further and permit special compensation in certain circumstances, and they may do that where there's an unusual situation or complexity to the estate or trust in administration, and where state law doesn't permit that. In some state laws, you may see formulas where a trustee, for example, gets a percentage of the asset value each year. Some states may pay a income-based compensation or some combination. In some states, there's a compensation structure based on distributions or paying out money from the trust. So you need to get your arms around all that. When you have that, then you can ascertain what compensation is permitted to be paid. You also want to look to see if there's any state law, common law, that modifies or supplements the statute. And this is why you really probably, at least initially, have a lawyer help map out what this is for you. Might case law change what's in the statute or interpret what's in the statute? So if a statute says reasonable compensation, what does that mean? And you may need to look to case law in the state. So in most cases, it's probably pretty simple. You look at the will and the trust, it'll say pay compensation is provided under state law. You can almost do a search online, find state law. It'll say this percentage of assets each year, this percentage of income or distributions, and a separate compensation structure for the final payout when you close out the trust. But in many cases, it can be much more nuanced, and you don't want to make the wrong decision. So compensation is really important. Now, a final perspective on this, these are the kind of considerations you want to think about when you're creating your documents, right? So if you're creating a will and you know you have a complex estate or you have a beneficiary with some very significant issues, maybe you want to talk to an attorney and understand what state law provides. Maybe you want to pay more than that. A lot of people take the position, oh, I don't want to pay family members for being a fiduciary. I don't need to. It's my brother, it's my cousin, it's this and that. Think about it from another lens. If you're not paying somebody to do this really important job and it takes time and effort, are they going to give it the attention they want? I would rather recommend that you start with the premise, I want to pay compensation. If somebody chooses to waive it, they can do so. But I don't want to put somebody in a position of having to do work and take on legal responsibilities and not provide compensation for them. So that's an important discussion. Too often it almost is not really thought about or looked at. Another point on compensation, and I mentioned earlier, agents under health proxies, they should not be compensated. I think it's a conflict. I think there could even be an issue if they're being paid. Some states may permit professional health proxies like a social worker or nurse to be appointed in that position. That's different. As to powers of attorney, the law will provide for compensation, but most power of attorney documents, and again, if you forget, a power of attorney is a legal document that names an agent to take legal, tax, and financial decisions if you're incapacitated, and sometimes it's not requiring incapacity. That's called a springing power. But does that person deserve compensation? Maybe. Think about the following not uncommon fact pattern. Somebody's diagnosed with dementia and lives for another 15 years, and the person under the power of attorney, because they don't have a revocable trust, for example, is paying all their bills, doing all their investing, and taking care of everything for them for 15 years. Why should they not be compensated? And those documents, powers of attorney, are too often treated as like an orphan in the planning and not really given enough attention. It could be very important. If you do a revocable trust, state law will probably provide for a compensation structure for the trustee, but you still, again, may want to address it in the trust. So bottom line is, compensation for fiduciaries is really important. Think about it in a broad, holistic way. You want to make sure that somebody's devoting their time, effort, and attention to do what's needed for you and your loved ones. It's not as simple as it sounds in some cases. In other cases, it's pretty straightforward. You look it up online, you got the statute, and do the calculation, you're done. But make sure you know that's the right answer. I think the better approach is, at least initially from step one, when you start with the trust or the estate administration, hire an estate planning attorney to make the calculation and give you a template of what it is, so you know what it is and you can consider or rule out all these ancillary considerations. Thank you for joining us. Please keep in mind that all the information in the video clip is for educational purposes only. Don't take any legal action without appropriate professional advice. For more information, see shenkmaneducation.com. Thank you.